2-minute warning, we are expecting Edward Stanton here in just a matter of moments. They're gathering, they're coming down to the news conference area right now. Again, this is a long time coming for the Darrius Stewart family and for our former officer, Connor Schilling. This incident happened back in July of 2015. So here we are now looking at an update on this criminal federal investigation. We are expected to get an update, and it does appear as if they are gathering right outside the door here. So we are going to step aside and let this press conference start.
Can we just scoot it up?
I mean, all of the mics are pretty good, too.
Okay.
U.S. Attorney's coming in now.
Good afternoon, and thanks everyone for coming out. Let me first introduce the individuals that are with me this afternoon. And I know that Mr. Goggins has already explained this is somewhat a pretty detailed statement that I want and plan to read. And any additional questions, I think the statement will address most of them. If not, feel free to follow up with Mr. Goggins. With me to my left is First Assistant U.S. Attorney Larry Lorenzi. To my right, Special Agent in charge, SAC, Michael Gavin with the FBI, and to his right, Special Agent Tracy Harris Branch, also with the FBI. On the night of July 17, 2015, 19-year-old Darrius Stewart was fatally shot by Memphis Police Department officer Connor Schilling. The shooting was investigated by the Tennessee Bureau of Investigation, and the TBI prepared a report for consideration by the Shelby County District Attorney General's office. In early November 2015, a state grand jury declined to indict Officer Connor Schilling on charges related to the death of Mr. Stewart. Following this decision, the Department of Justice launched an independent, comprehensive, and careful review of the evidence collected relating to the shooting of Stewart. We recently concluded our independent federal review of Stewart's fatal shooting. And after a thorough review of the facts surrounding the matter, we found insufficient evidence to support federal criminal civil rights charges against Connor Schilling. I, along with prosecutors from my office, earlier today we met and spoke with Mr. Stewart's division of the Department of Justice and the FBI, conducted a complete, independent, and thorough review of the events surrounding Mr. Stewart's death before making this decision. In conducting the review, we were tasked with determining whether the events that led to the death of Stewart gave rise to a federal criminal civil rights case prosecutable under the applicable law, that is, Title 18 United States Code, Section 242, also known as deprivation of rights under color of law. Under Section 242, it is a crime for a law enforcement officer acting willfully to deprive an individual of their constitutional rights. To establish a violation of Section 242 in this case, the government would have had to prove beyond a reasonable doubt that Officer Schilling willfully deprived Stewart of his constitutional rights. We extensively reviewed information obtained by the MPD and the TBI during the investigation, which included interviews of all civilian witnesses and a video of portions of the incident taken by a witness. In addition, federal prosecutors and investigators met and consulted with the Shelby County medical examiner who performed the autopsy of Stewart and a TBI forensic scientist who conducted tests in the case. Schilling's statement to MPD was also reviewed. For the Justice Department to file criminal civil rights charges against Schilling, the government would have to prove beyond a reasonable doubt that Schilling, acting under the color of law, willfully deprived Stewart of his constitutional right. Now, Now, this test, it has two requirements. First, the officer had to violate the constitutional rights of an individual by using an unreasonable amount of force. And second, the officer had to act willfully, that is, with a bad purpose to violate the law. Again, after a thorough review of the facts surrounding the death of Mr. Stewart, it was determined that there was insufficient evidence to prove beyond a reasonable doubt that Connor Schilling violated Section 242. In assessing the reasonableness of the use of force, one must consider the totality of the circumstances, including in particular whether the suspect poses an immediate threat to the safety of the officer or others, and whether the suspect is actively resisting arrest or attempting to evade arrest by flight. The use of deadly force is justified when the officer has probable cause to believe that the suspect poses a threat of serious physical harm either to the officer or to others. Deadly force can be reasonably employed where an officer believes that the suspect's actions place him or others in the immediate vicinity in imminent danger of death or serious bodily injury. Even if sufficient evidence of unreasonable force existed, the government must additionally show that the officer acted willfully, that is, with a bad purpose to violate the law. Willfulness is one of the highest standards to meet under the law. The totality of the available evidence indicates that just prior to Schilling firing his weapon, Stewart was in control of Officer Schilling's police handcuffs. According to Schilling, Stewart was actively resisting arrest and represented an immediate threat to his safety. The presented evidence in this case does not contradict Schilling's assertion that Stewart was resisting arrest. In fact, much of the evidence corroborates. Review of MP's radio recordings of the Station B transmissions established that Schilling was advised that Stewart had outstanding warrants for his arrest, that the Iowa authorities would extradite Stewart, and that Schilling should transport Stewart to the police station. Mr. Stewart left Iowa following allegations of criminal conduct there, which may have provided a motive to evade arrest. Additionally, the footprint on the rear door of Schilling's patrol car, though not forensically matched to Stewart's shoe, provides some corroboration of Schilling's claim that Stewart kicked the car door into Schilling and charged out at him. Stewart's active resistance to arrest weighs against a finding that Schilling's use of force, in this case, was unreasonable. The evidence also cannot prove that Schilling did not reasonably believe Stewart posed an immediate threat to Schilling's safety. It is uncontroverted that Schilling and Stewart engaged in a violent struggle several minutes, moments before Schilling shot Stewart. Video evidence confirms that Schilling and Stewart struggled on the ground and that, at one point, Stewart was able to get on top of Schilling. Schilling's injuries further attested the violence of the struggle. Crime scene investigators observed and photographed bruises and abrasions on Schilling's face, arms, and legs. The evidence also does not prove beyond a reasonable doubt that Schilling's second shot was unreasonable. Much of the evidence tends to show that the second shot followed only a few seconds after the first. Additionally, since eyewitness accounts and physical evidence indicate that the second shot came very soon after Stewart stood up and while he and Schilling were in very close proximity, the evidence cannot establish beyond a reasonable doubt that at the time of the second shot, the threat initially posed by Stewart had abated. In light of the uncontroverted evidence that Stewart and Schilling engaged in a prolonged and violent struggle before Schilling shot Stewart, the evidence does not establish beyond a reasonable doubt that Schilling violated Section 242. Finally, if Schilling's shooting were unreasonable, the evidence is insufficient to prove beyond a reasonable doubt that Schilling acted willfully. It should be noted that the law states that mistake, fear, misperception, or even poor judgment do not constitute willful conduct prosecutable under the law. Given the circumstances of the violent struggle, Schilling's statement that he was exhausted and the weapons available to Stewart, the evidence cannot prove beyond a reasonable doubt that Schilling shot Stewart knowing that the shooting was unreasonable. Nor does Schilling's demeanor, as observed by others, suggest any animosity, deception, or other attitude from which willfulness may be inferred. Nothing in Schilling's prior record or the tone or substance of Schilling's recorded radio transmissions indicates the standard of willfulness. Ultimately, the evidence is not sufficient to meet the rigorous requirements of proving beyond a reasonable doubt the elements of Section 242 in this case. Even if there was reliable evidence that indicated that Officer Schilling's actions were unreasonable, there's insufficient evidence to prove beyond a reasonable doubt that he acted willfully, that is, with a bad purpose to violate the law. Therefore, after a careful and thorough review, a team of experienced federal prosecutors and FBI agents determined that the evidence was insufficient to prove beyond a reasonable doubt that Connor Schilling violated the federal criminal civil rights statute. Accordingly, the review into this incident has been closed without prosecution. I want to mention that we take very seriously all allegations of civil rights violations. In fact, as many of you all know, we have a very active and dedicated civil rights unit here at the U.S. Attorney's Office for the Western District of Tennessee. The Justice Department aggressively prosecutes criminal civil rights violations whenever there is sufficient evidence to do so. I will also add this, that we're working to address the deep concerns that we've heard over the past months so that we can have a healthy and productive dialogue that can help prevent such tragedies in the future. We're looking at working with the Department of Justice's Office of Community-Oriented Policing Services, also known as COPS, on a collaborative reform initiative that will exclusively benefit the Memphis Police Department. You'll hear more about this initiative in the upcoming weeks. The Memphis Police Department has formally requested to participate in the collaborative reform process with COPS. Collaborative reform is an independent and objective initiative to help the department make organizational changes through examining its policies, practices, training, rules, and procedures around key issues. By going through this process, the Department of Justice can help police departments identify areas that need improvement and then recommend needed changes. Collaborative reform has been found to be productive, to produce positive change in police departments across the country, including Las Vegas, Philadelphia, and Fayetteville, just to name a few cities. And by connecting the MPD with COPS, we're hopeful our city's police department will not only bolster its efforts to protect and serve the greater Memphis community, but also strengthen its relationships with those who reside within the community.